So ladies and gentlemen, greetings from Hong Kong. My name is Jintao. I'm counsel at CIETAC Hong Kong Arbitration Center. Thank you so much for joining us online today as part of the 2023 Paris Arbitration Week. Also a very big thank to the European Chinese Arbitrators Association, the Hong Kong Institute of Arbitrators, JAMS, and of course the Paris Arbitration Week organizing committee for their very kind support to this event. Today's webinar will be focusing on resolving disputes relevant to sport and sports-related commercial disputes. We have the honor to invite 5 experts in the fields of sports law and arbitration to share their practical insights and experiences on relevant topics. It is worth mentioning that all our speakers today have engaged in arbitration services during the Olympic Game period for the 2022 Tokyo Summer Olympics or the 2022 Beijing Winter Olympics. I truly look forward to the sparks during the discussion later on today. Well, today's webinar is spontaneously conducted on Zoom and live streamed on WeChat. So for those of you joining us from Zoom, please feel free to type your questions onto the Q&A box so that the speakers can see them and answer them later on. So, all right, without further ado, let's move on to our first session on the agenda. Mr. Chengjie Wang, Vice Chairman and Secretary General of CIETAC, has pre-recorded his welcome remarks by video.
来自世界各地的各位嘉宾朋友们，大家上午好，晚上好。我代表中国国际经济贸易仲裁委员会，欢迎各位与会嘉宾和观众参加本次在巴黎仲裁周期间由贸仲主办、贸仲香港仲裁中心承办的奥运会与仲裁、就地体育及相关商事纠纷解决线上研讨会。法国巴黎作为世界上享有盛誉的城市，有着举世闻名的埃菲尔铁塔、优雅秀丽的塞纳河以及数不清的文化瑰宝。美国人眼中的巴黎各有不同，在仲裁人眼里，巴黎具有独特的魅力。根据2021年英国伦敦玛丽女王大学和美国维凯律师事务所发布的2021年国际仲裁调查报告显示，巴黎是全球排名前5位的首选仲裁地点，在国际仲裁领域拥有着公认的良好声誉。作为唯一一个在巴黎仲裁周举办活动的中国内地仲裁机构，贸仲十分荣幸，也非常期待。贸仲于1956年设立，是中国最早设立的商事仲裁机构。60多年来，贸仲妥善处理了以涉外争议为主的商事仲裁案件5万余件，案件当事人涉及150多个国家和地区。仲裁裁决在世界范围内，包括英国、法国在内的欧洲国家和地区得到广泛承认与执行。根据刚才提到的2021年国际仲裁调查报告，贸仲被评为全球最受欢迎的5大国际仲裁机构之一。2018年，在中国国际贸易促进委员会、中国驻奥地利大使馆、维也纳国际仲裁中心的共同见证下，贸仲在奥地利维也纳设立了贸仲欧洲仲裁中心，构筑中国仲裁界与欧洲各国仲裁界之间互动、沟通、合作的桥梁。在2021年中国仲裁周期间，贸仲欧洲中心在西班牙马德里和奥地利维也纳举办了多场活动，吸引了来自奥地利、德国、瑞士、法国、匈牙利和斯洛伐克的律师、仲裁员等3000余名与会者线下线上参与，取得了良好的反响。贸仲是中国仲裁的国际品牌，贸仲的国际化有着夯实的数据支撑。2022年，贸仲共受理了4086件案件，案涉争议金额连续5年再过1000亿元人民币。贸仲受理的涉及一方当事人为境外当事人的案件有642件，其中双方均为境外当事人的国际案件数量同比增长36%。案件涉及83个国家和地区，当事人涉及包括德国、法国、英国、奥地利、意大利、葡萄牙、土耳其、比利时、爱尔兰、瑞士、波兰、芬兰、瑞典、荷兰、罗马尼亚等17个欧洲国家。 案涉纠纷类型主要包括股权投资、金融证券和建设工程等。当事人约定适用法律包括联合国国际货物销售合同公约、香港法、英格兰、威尔士法律等大量国际商事合同约定的实体适用法。涉外仲裁案件的高质量裁判离不开多元化、国际化、专业化的仲裁员队伍。贸仲现有在册仲裁员中，外籍及港澳台地区仲裁员有591人，占比31%。仲裁员来自144个国家和地区，涵盖112个“一带一路”国家和地区，能为来自不同背景和文化的当事人提供独立、公正、高效的仲裁服务。其中，来自英国的仲裁员有54位，来自德国的仲裁员有20位，来自法国的仲裁员有13位。这些数据在中国内地的仲裁机构中首屈一指。近年来，大量欧洲企业都会选择贸仲作为争议解决机构，反映了对贸仲和贸仲仲裁员公平、快速、高效解决争议的信心。除了办理国际仲裁案件，贸仲还大量举办各类以国际仲裁为主题的活动。早在2004年，贸仲就在北京承办了国际商事仲裁委员会国际仲裁大会，将国际商事仲裁委员会国际仲裁大会首次带到了中国。2013年，贸仲与中国人民大学法学院、中华全国律师协会、北京市律师协会联合发起举办首届中国仲裁周活动。10年后，也就是2022年，贸仲成功举办了第10届中国仲裁周活动，在全球范围内，包括加拿大、西班牙、肯尼亚、奥地利、巴西、俄罗斯、印度、南非、意大利、迪拜等境外12国以及国内近20个城市，贸仲举办了52场活动，来自141个国家和地区，约316.3万人次在线收看，广受业界关注和好评。作为中国历史最悠久、规模最大的国际仲裁机构，贸仲积极推动中国涉外法律人才队伍建设。去年，贸仲成功举办第20届贸仲杯辩论赛，来自93支参赛队1000余名境内外选手踊跃参赛，27个国家和地区230位专家担任仲裁员。期间，贸仲还举办了 Voice of Water 系列线上直播活动15期，逾35万人线上参与观看，为参赛选手提供专业指导，丰富参赛体验。贸仲还成功举办第14届法兰克福国际投资模拟仲裁庭赛事预选赛，选拔和培养仲裁业界急需的涉外投资争议解决青年法律人才。2022年，贸仲与北京大学、中国人民大学、香港大学等15所境内外高校签署合作协议，设立硕士联合培养项目，推荐专家担任导师或开设国际商事投资仲裁课程，为培养具有国际视野、通晓国际规则、胜任跨境法律服务的中国涉外仲裁人才贡献力量。贸仲内设的教研学一体机构中国贸仲国际仲裁研究院于2022年推出为期3个月的联合国国际货物销售合同公约国际课程，全球近20个司法管辖区近1500名学员参与，在线浏览量突破12500人次。女士们、先生们，今天研讨会的主题是体育及体育产业相关商事纠纷的争议解决。第33届夏季奥运会将于2024年在法国巴黎举行，这也是巴黎相隔100年后再次举办夏季奥运会。在本届巴黎仲裁周期间讨论这一话题，可谓是恰逢其时，恰逢其地。2022年，北京冬奥会和卡塔尔世界杯相继成功举办，吸引了世界人民的目光。以2022年北京冬奥会为例，运动赛场上不乏阿迪达斯、Visa、可口可乐等国际品牌赞助商的身影。此外，体育赛事相关的广播和媒体权利、赞助权、衍生商品产业、体育博彩等，带动了体育经济的高速发展。中国知名企业，例如腾讯、高瓴资本、小米等，亦先后布局细分体育产业的细分赛道，推动了中国体育经济的高速发展。经中国国际体育总局测算，到2035年，中国体育产业总量将占 GDP 的4%左右，约8.36万亿元人民币，也就是1.14万亿欧元。中国体育产业将成为国民经济发展的支柱性产业。 随着体育经济逐渐繁荣，随之而来的一系列涉及体育经济的纠纷值得关注。2022年，贸众主办的贸众直播间冬奥在身边体育经济解决系列研讨会，邀请了多名著名体育经济解决专家，聚焦于奥运会期间的体育仲裁、体育赛事中的赞助和转播权纠纷、运动员合同纠纷、体育经济解决中的惩罚措施几个话题，助力体育经济参与者做好法律风险防范，为行业人士提供体育经济解决新思路。本次研讨会是由贸众于2012年在中国内地以外设立的第一家分支机构贸众香港仲裁中心承办。贸众香港仲裁中心默认适用贸众仲裁规则和香港仲裁程序法律来管理仲裁案件。自设立以来10年间，贸众香港仲裁中心管理的案件中，有67%的当事人来自境外，包括德国、比利时、法国、卢森堡等欧洲国家和地区，且有接近一半的案件使用英语或中英双语作为仲裁语言。我从我香港中心的同事那里了解到，贸众香港仲裁中心也承办了不少涉及体育产业的争议金额较大的商事纠纷。本次研讨会聚焦体育产业争议解决，邀请了多名国际知名的体育争议解决专家，围绕体育仲裁和奥运以及仲裁解决体育相关商事纠纷两大话题，就体育活动和体育经济产业相关的亟待解决的法律问题，为各位提供多角度、全方位的分析和讨论。最后，我预祝本次研讨会硕果丰收，巴黎仲裁周圆满成功。同时，欢迎各位关注即将于今年9月份在中国杭州市举办的第19届亚运会。祝各位身体健康，工作顺利，谢谢大家。
All right, now let's move on to the second session of our webinar today. I'm going to pass the floor to Mr. Xian Yuebai and Professor Song Lu. Mr. Xian Yuebai is managing partner at Guanghao Law Firm Tianjin office. He serves on the CIETAC panel and the CAS panel. Mr. Bai was appointed as one of the 6 members of the ad hoc division of CAS for the 18th Asian Games and was appointed as the only member of Chinese nationality of the ad hoc division of CAS for the 2022 Beijing Winter Olympic Games. He is also an arbitrator and counsel in many domestic and foreign-related cases at several arbitration institutions. And Professor Song Lu is professor of law at China Foreign Affairs University. He serves on the CIETAC panel and the CAS panel. Professor Lu has served as arbitrator of the ad hoc division of CAS for the 2020 Tokyo Olympic Games. Besides, he served as arbitrator since 1989, having been involved in hundreds of arbitrations under the rules of CIETAC, HKIC, SIAC, ICC, SCC, and UNCITRAL. Now, over to you, Mr. Bai.
Thank you, Jintel. You hear me okay? Yeah?
Perfect.
Okay, let me put on my PowerPoint. So can you see the PowerPoint now?
Couldn't see just yet. Can you share?
Okay. Hold on a sec.
It's okay now.
Okay, good. Hi, good afternoon and good evening and good morning, everyone. Thank you for being part of today's webinar. The theme for today is Olympic Games and arbitration. I will focus on Olympic Games and sports arbitration. This is quite an interesting topic with so many things to discuss. I hope I will be able to touch upon some of the fun part of this very interesting and very unique area of arbitration that is sports related. Today, in general, I will cover 3 topics. First of all, how did CAS, that is the Court of Arbitration for Sports, started, and its relationship with the international sports arbitration. And the second topic that I will touch upon is the ad hoc division of CAS that is set up for the occasion of Olympic Games. and then I will kind of summarize some of the unique features of CAS arbitration. First of all, where did and how did the Court of Arbitration for Sports started? The genesis of a CAS really started in 1980s, when the number of international sports-related disputes were rising rapidly, and the parties involved in those sports-related commercial disputes or sports-related disputes were a bit baffled and confused of where to initiate such type of legal proceedings, because apparently at the time there was no independent international judicial authority to handle this type of disputes. And also national courts obviously were not a good option because the national laws across the world are different, and the enforcement would also be a problem because not every court judgment from a particular country can be enforced easily or readily in other countries. So there was a lot of confusion, and there was a lot of problems facing the sports industry and International Olympic Committee in particular. In 1981, His Excellency, how I should call, Juan Antonio Samaranchi, came into the helm of International Olympic Committee. He was elected that year as the president of IOC. So he came up with this idea: why don't we establish an international body that is in charge of the sports-related dispute resolution, which can transcend national boundaries. So Court of Arbitration for Sports, that is CAS, is the brainchild of Mr. Samaranchi in 1981. He set off a series of actions that led to finally the establishment of Court of Arbitration for Sports, CAS. By the time of 1984, CAS became finally operational once the statute of CAS at the time was finally approved. So it became the first ever specialized authority in settling, resolving international sports-related dispute. And the idea is to offer a flexible and efficient and inexpensive procedure to resolve this type of disputes. As it stands now, the structure of CAS is composed of several different, I would call, sections. First of all, the most important one is ICAS, what we call. It stands for International Council of Arbitration for Sports. At the moment, it has 22 members. It used to be 20, now it became 22 members. And among them, all these 22 members are from quite a variety of different jurisdictions and countries. And among these 22, there are 5 board members, the board of the ICAS. I would talk more about ICAS later on. In terms of the other component of CAS is Court Office of CAS, which is responsible for the day-to-day kind of administrative issues of the CAS. It interacts with the parties, receiving and sending out notices to the parties, corresponding with the parties, etc. And when it comes to the 3 divisions, there are 3 divisions specialized in different types of cases. The ordinary arbitration division is in charge of the commercial side of the sports-related disputes. It's a sole instance, just like other commercial arbitration institutions. It is a sole instance proceeding. with a final award being, effective without any appeal procedure available, of course. And then you have the appeal arbitration division that is dedicated to cases that are brought to CAS as a result of kind of a dissatisfied with a decision from an international federation, for example, for a particular sport or other international sport organizations. It has then the CAS anti-doping division, which was set up quite recently, back in 2019. This, as its name indicates, is specializing anti-doping cases. Another component which was only established for the occasion of Olympic Games, that is the CAS ad hoc division. It does not exist most of the time. It came into being, well, every edition of Olympic Games, both Summer Olympic Games and Winter Olympic Games. So you would have a CAS ad hoc division. It usually created 10 days before the Olympic Games, and it will exist for the duration of the Olympic Games, and then will be dissolved by the end of the Olympic Games. So it started back in 1996 when the Atlanta Summer Olympic Games was held in the US in Atlanta. Of course, the arbitrators are always the important factor or important player in this dynamics of the court arbitrations for sports. So you have 3 lists of CAS arbitrators. They are specialized in different areas. There's a generalist of arbitrators. There's also a football specialized list of arbitrators. And additionally, there's a list of arbitrators for anti-doping cases. One thing noteworthy is the arbitrators on the list of anti-doping cases cannot act as arbitrator on other panels that are handling other cases like football or general cases. Over the years, CAS has been evolving, and there have been quite a number of landmark events that has led to the reforms of CAS. So what the CAS that we see now or today has really experienced quite some significant changes and reforms over the years. So one of the high-profile cases that has led to the reform is in 1992, there was a famous case called Gandel case. Mr. Elmar Gandel is a German-born jockey. So he was very active at horse riding, and he was disqualified or he was suspended by the FEI, that is the Federation for International Equestrians, because of a doping case involving the horse. It's quite an interesting case. So he filed a case with the CAS, and CAS actually reduced the suspension from 3 months to 1 month. But still, he was a bit dissatisfied with the CAS award. He made then appeal with the Swiss Federal Tribunal and challenging basically the impartiality and independence of CAS, claiming that CAS is not a true independent dispute resolution body because of the so many links with IOC. IOC basically can dictate everything of CAS. His appeal to the Swiss Federal Tribunal was finally dismissed. In the meantime, however, Swiss Federal Tribunal raised quite a few questions, which can, from a certain perspective, be interpreted as calling into question the independence of CAS. For example, the fact at the time was CAS was financially almost exclusively financed by IOC at the time. And the IOC was able to modify or to amend the CAS statute. And also the IOC president wields considerable power to appoint members of the CAS. So that means IOC to a large extent can control many things that can happen at CAS. For example, when IOC is a member or is a party to a particular dispute, which happens all the time, particularly when the Olympic Games is going on. For example, the cases that are within the jurisdiction or have been handled by the ad hoc division of CAS over the years of the past several edition of Olympic Games, both Winter Games and Summer Games, you would have many cases that would have IOC as one of the parties, or at least as interested party. So when this type of a situation happens, the question raised by Swiss Federal Tribunal is really relevant and makes a lot of sense. So that's why this case prompted the CAS and IOC decided to introduce major reforms. So in 1994, because of this case, because of the decision by the Swiss Federal Tribunal, so CAS and IOC decided to make major changes to CAS. That is why in 1994, International Council of Arbitration for Sports, as I mentioned earlier, the ICAS was set up, being the supreme organ of CAS, replacing IOC and making it more independent from IOC. Thanks to this reform, CAS began to enjoy a better kind of a reputation in terms of the independence. So over the years, since this reform happened during the Paris Agreement in 1994. So since that major reform in 1994, all Olympic international federations and many national Olympic committees have recognized the jurisdiction of CAS. Since 2003, Olympic movement and numerous governments have promulgated the World Anti-Doping Code, making CAS the ultimate appeal body. Over the years, as everybody knows, anti-doping has become one of the major issues, one of the, I would say, most important issues that IOC and the CAS has to confront. So later on, at a later stage, the CAS ADD was established. But well before that, since 2003, the WADA code has been recognized and officially also making CAS the appeal body for any disputes involving doping cases, doping issues. ICAS, the purpose of ICAS, according to the statute of ICAS, is to facilitate the resolution of sports-related disputes through arbitration or mediation. The CAS does have a mediation procedure as well. I won't talk too much about that. That is a separate procedure, separate set of rules, etc. So I simply focused on the arbitration side of the things. So the purpose of ICAS is to safeguard the independence. If you summarize the mission of ICAS is to safeguard the independence of CAS and the rights of the parties, basically making sure that the parties' procedural rights are observed and respected, which is an indispensable part of the judicial due process, I would say. And in terms of a responsibility, ICAS is responsible for the administration and financing of CAS. ICAS members, as I said earlier, the 22 members at the moment, they exercise their function in a personal capacity with total objectivity and independence. The members of ICAS, I'd like to point out here, they are not part of the legal proceeding. That is, they don't themselves get involved in any specific cases. They're supposed to be impartial, they're supposed to be independent, and they don't get involved in any. So they don't get in the decision-making, the deliberation, whatever. So they are keep themselves away from specific cases. That is one way to ensure the independence of CAS. now, as I said earlier, I'll move on to ad hoc division cost for the occasion of Olympic Games. As I said, in 1996, ICAS created for the first time the ad hoc division of cost because apparently, if you think about it, whenever there's an Olympic Games happen, there are thousands of people involved in each game, and there are so many events, so many competition going on within a very short period of time, a few weeks. And invariably, there's always something going on. There's always some dispute that would happen. So ICAS decided it might be a good idea to have a ad hoc division to handle this type of disputes that arise, particularly or especially for during the Olympic Games. That's how it came into being. And one of the other major concern is ICAS and IOC do not want national courts to intervene in any sports-related dispute, particularly Olympic Games. So they want their own dispute resolution mechanism in place to resolve any problems that might happen. So ad hoc division came into being in 1996. Of course, because of time is of the essence, you have so many different events happening within a few days. So the dispute resolution has to be expeditious. It has to be resolved as quickly as possible. So the time limit was 24 hours for any disputes that arise during the Olympic Games. Generally speaking, the composition of the ad hoc division for the Summer Olympic Games at the moment was 2 co-presidents and 12 arbitrators, usually from different jurisdictions, and they would stay on site at the Olympic City, wherever that happens, throughout the games. For the Winter Olympic Games, the size of the arbitrators are smaller, I would say. Like, for example, the 2022 Beijing Winter Olympic Games, we have 9 arbitrators for the ad hoc division. But for the summer edition, which, for example, the Tokyo Summer Olympic Games, which Mr. Lu attended, Professor Lu being one of the ad hoc division members, there were 12. For the ad hoc division of the CAS set up for the Olympic Games, there's a set of special procedure rules created for the Olympic Games. Again, they are simple and flexible and free of charge for the parties. As I said earlier, since 1996, there has been a ad hoc division for each edition of the Olympic Summer and Winter Games, and it proved to be a great idea and quite effective. Also, this idea of having a ad hoc division for international sports events has been introduced into other international sports events, such as, for example, Commonwealth Games since 1998, the UEFA European Championship since 2000, FIFA World Cup and Asian Games, and another few international games as well. One interesting feature that I personally find is for the CAS ad hoc division is you would invariably have interested parties involved in the dispute or in the proceeding. The interested parties in commercial arbitration, it's difficult or it's not easy to have an interested party or third party to be involved in the proceeding. You need to seek the approval or consent from both parties, as well as the consent of the third party, etc. So it's kind of complicated. But for the CAS ad hoc division cases, it's very often to have interested parties in IOC, the international federations, or national Olympic committees, etc. So it's pretty frequently seen that you have interested parties being part of the proceedings. They might have a stake.
Sorry, Mr. Bai. Sorry to interrupt. I think their time is running up, so
Okay.
appreciate if you would finish in 2 minutes and pass to
Okay.
Professor Lu. Thank you so much.
Thank you. Yeah. Okay, I'll very quickly move on. So the third party is supposed to file they can file amicus curiae in terms of a third party position on particular issues of law, etc. So that's quite interesting. The 24-hour time limit, I will skip that. I mentioned that already. And also the division, the whole division of the CAS has a very limited jurisdiction, as I mentioned. It covers the cases either that arise during the Olympic Games or 10 days preceding the opening ceremony of the Olympic Games. There are cases that the parties are denied jurisdiction simply because the case doesn't arise within that time limit. The applicable law, I would skip that in terms of the cases for the whole division, and the procedural law, I wouldn't talk much about that. And then some of the unique features, I've already touched upon this. There are 3 divisions. Each division has its own procedures. The panel arbitrators for CAS is a closed list. Any arbitrator has to be on that list. Anyone, unlike commercial cases where you can choose arbitrators, or many of the commercial institution doesn't have a list at all. But for CAS cases, you have to choose arbitrator from that list. And enforcement is not always a problem, and rarely actually a problem in CAS cases. That is something very different from commercial arbitration. The noble principle for the appeal cases, the panel has a full power to review the facts and the law. It doesn't have to be restricted or confined by what happened during the first instance, for example. Applicable law, regular appeal cases, I wouldn't touch upon that. I think this is something I touched already. A time limit, again, 21 days. That's just a very short period of time. So being a party, you have to be aware of the time limit. Otherwise, you would miss the deadline. And usually for regular cases, the time limit or time period for the panel to issue an award is 3 months. But of course, it can be extended on some occasion. There are legal grounds to do so. Finality is final. Usually, very exceptional cases, you can appeal to the Swiss tribunal. Publicity, the award, particularly the appeal, the disciplinary cases, it is supposed to be made public, unless the parties agree otherwise, but it happens very rarely. So most of the cases are made public. It's supposed to be made public. Thank you. That's all from me. Can you hear me?
Yes, Professor Lu, you are mute.
Well, thank you. Thank you for. I think Mr. Bai has given a brief but accurate description of the CAS and the CAS relations with Olympic Games. In the interest of time, I would only add, a few points. Number one, CAS is a type of arbitration, like other arbitration, based on, like commercial arbitration, based on parties' agreement. In the example of Olympic Games,
I cannot hear. Mr. Oh. Professor Lu, we lost you for a few seconds. Disconnect. Yeah.
Can you hear me now?
Yeah, it's good now. Yeah, go ahead.
The CAS arbitrations, like other commercial arbitrations, based on the parties' agreement. In the case of Olympic Games, the Article 61 of the Olympic Charter and paragraph 2 stipulated that that the CAS would have jurisdiction over dispute occurred during the Olympic Games, and when every participant, every athletes and coaches, when they join the Olympic Games, they have to filling an entry form. So those two documents combined together will be considered an arbitration agreement. So this is based on a party's agreement. Of course, there are some observations and even criticism about this, but still, basically, this is an arbitration based. This is a dispute resolution based on the parties' agreement. Second, as Mr. Bai mentioned, during the Olympic Games, most dispute will fall into two types. In the first part of the ad hoc division, the dispute would centered on what we call eligibility and selection dispute. That means some athletes, some players, they will come to CAS and say, although I'm disqualified, I should be qualified to participate in the Olympic Games. So that's the first, during the first phase of the Olympic Games. And then in the second part, the dispute will be mainly what we call the field of play dispute. It's a judge's decision, the umpire decision of a competition, those kind of dispute. So the feature of the ad hoc division of the CAS to Olympic Games is that it's very quick. Normally, the operative portion of the award will be communicated to the parties within 24 hours. So that is a feature of the ad hoc division arbitration. So because of the time, so I would not say anything more, but if anyone have any questions, so I'd be happy to answer them afterwards. Thank you.
Thank you so much, Professor Lu, and thank you so much again, Mr. Bai, for your very practical sharings and the introduction of CAS arbitration. Now I'm going to invite Ms. Guo Cai and Ms. Raphael Schneider. Ms. Guo Cai is a partner of Jinmao Law Firm, specialized in international dispute resolution and sports law. She is particularly good at facilitating understanding between parties from different cultural backgrounds and resolving disputes by way of amicable settlement. In Chinese, 话干戈为玉帛. Apart from private practice, she is actively involved in sports governance both domestically and internationally, and currently appointed to the International Cricket Council Dispute Resolution Committee. And Ms. Raphael Schneider is a partner at Brandon in Zurich, a CAS arbitrator for many years, as well as a commercial arbitrator and judge at the appellate court. Her practice focuses on dispute resolution of commercial and sports matters as an arbitrator, and she has a long experience coming from numerous cases under different arbitration rules. She has studied in Freiburg, Switzerland, and Turning University in the US, and rendered arbitral awards in French, German, and English. Now over to you. Thank you.
Thanks, Jintao.
Thanks,
thanks everyone for watching, and it is really my pleasure to be invited to join this wonderful event, because after 3 years of COVID, it feels like it's like saying hello again to the road, because I feel it's like CIETAC effort to actively get involved in the road again. So recently I went to Europe, Singapore and Hong Kong after this like 3.5 years of not going abroad. And I feel like the road is very different right now, and the impact of COVID has run very deep and lasting in any societal sector, as in sports. So I feel like it's more important right now than ever to communicate with each other and to meet and to understand each other. So this event, I think, facilitates a wonderful opportunity, even just remotely. And I really hope that next year and going forward, we can meet often again in person. Because we already have this presentation, so Rafaela and I already discussed that probably we could be more interactive in this session. So I will probably invite her to comment my points along the way, rather than waiting after the conclusion of my presentation. So first of all, I think as you also see, realize from Mr. Bai's presentation right now, sports arbitration or sports dispute resolution is very interesting, especially in a sense that it's always promoted, or it always evolves based on the society's involvement, and like the current practice of CAS, or even the establishment of the CAS ad hoc tribunal or dispute resolution mechanism during the Olympic Games is actually promoted by practice, like and actual cases, like the Gandos case, right, in 1994, that promotes the true independence of CAS. And also you might recall the landmark case of Pechstein, which promotes for the public hearing, that also helps the live streaming or the public hearing of the notable case of Chinese athlete Sun Yang versus FINA. And also but I think that's also due to the society's participation in sports industry. And also I would particularly mention the pro bono services for the Olympic Games. Just in light of the upcoming 2024 Paris Olympic, based on our experience in setting up the Pro Bono Council program for the Beijing 2022. So this is a service that was mostly promoted by, I think, the lawyers' initiative. So CAS will be involved in guiding the process, but based on our experience for Beijing, it's actually requires a lot of self-initiatives by the Lawyer Society or the Bar Association. So for anyone watching our presentation who are involved in the Paris Bar or the local arbitration commission in Paris, I would encourage you to find out the process and probably get involved in setting up the program early and get in touch with CAS early, so that you will have a more established and well-trained panel, a pro bono panel of lawyers for the Olympic Games next year. So for the our topic today, I and Rafaela will focus on mainly on the types of sports-related commercial disputes, as well as why arbitration is preferred method for resolving disputes in the sports sector. So for the types, I think it's mostly like two types for commercial sports-related disputes. One is the very normal contractual disputes between equal parties, like licensing disputes, such as licensing broadcasting rights from the rights holder to the local operator, sponsorship, an agency agreement, or even IP-related disputes. So just give you some vivid example. So you must be hearing that in the big money era of Chinese football, there is like always a series of landmark deals like PPTV's buyout of the licensing rights, broadcasting rights of the English Premier League, which is rather expensive. But the good season doesn't last very long and was interrupted by COVID. And also the interruption of COVID has increased this type of disputes in the sports sector, because the local operator like the PPTV in China, they no longer have this good revenue stream to keep paying the like the English Premier League, the rights holders. So usually there are a number of these kind of disputes chasing for payment. So I believe this dispute is still in the English courts, and I have no idea right now where it is, where the proceeding is, but it's a very expensive and long running litigation. And for IP-related disputes, I guess the audience from China probably will be familiar with a series of IP cases relating to the dispute, whether the live streaming of sport events, like live streaming of EPL, live streaming of Chinese Super League, qualify for work or intellectual property protected by the Chinese law for intellectual property. So right now, it doesn't seem like a debatable question, because for everyone involved in sports, you will agree that the broadcasting of sports events is a creative process that qualify for protection by the law of the intellectual property. But back to like 10 years ago or 5 years ago, it is a debatable issue in China, and I believe in some part of the world as well. So it actually took a number of cases, actual cases, and then a few years for the Chinese court to determine that live streaming of sport events, football games, basketball, or even NFL, they are all work protected by the Chinese law. So this vividly testified, it's a vivid testimony that sports law in China or in other part of the world, it's always promoted or evolved by the help of the actual case and the athletes. And we could touch upon this later when we discuss even the current trend for Chinese athletes promoting and advocating for their rights, especially like for overdue salaries. So these are the disputes between equal parties that are controllable. So, and also like to mention that from January 1st of this year, China has established its Sports Arbitration Commission of China, which is long absent, even though it was provided actually in the old sports law promulgated 17 or 2 decades ago, 18 years ago. So I would like to mention that for these kind of contractual disputes between different parties, actually, it was not the monopoly of this Sports Arbitration Committee to arbitrate because it's economic disputes and it is always up to the parties' consent. So the parties can actually choose to go to all kinds of forums like the courts or commercial arbitration commission or mediation, or they could go to the Chinese Commission for sports arbitration. So this is the first kind of dispute that between equal parties, contractual, which is easy, and also very commonly seen and involving a lot of money. And there are also a relatively special type of economic disputes. That is dispute between, for example, the athletes and their employers, especially football players and their employers. So this is in essence is actually employment-related disputes, but it is special because, for example, in football, if you are so there are 2 ways, there are 2 possibilities for this type of disputes. One is that you can exclude arbitration entirely, because Rafaela, she could later comment on this point, because in Switzerland and in some other country, including China, employment-related dispute is non-arbitratable. So you have to go to the People's Court or Swiss court for arbitrating these kind of disputes for salaries. However, FIFA has implemented such established and extensive mechanism for resolving this type of salary disputes, which is often applicable to foreign related, like disputes between a foreign player or foreign coach and a Chinese club. So I think the Chinese party have learned so many lessons from this kind of disputes. So I think for, whether you want to, as a player, for example, you probably want to choose the FIFA or even the CFA mechanism, because it's more sports oriented and the enforcement mechanism is very clear cut. For example, if the employer, your club doesn't pay you in according to the award or any decision, then the club can't get licensed. I think this point is actually highlighted recently by the Chinese media, and it has been aware of by increasing number of Chinese athletes. And we all know that some of the athletes and players, they publicly advocate for their rights, that their club haven't kept up their words and haven't paid them. So they'd rather like the club didn't get licensed for the next season, but they are now like standing up, protecting their rights and urging the club and the public to respect contractual responsibility and the athletes' rights. So I think this is even though that we have to sadly witness the departure of some of the football clubs, but I think we have to also applaud this kind of progress by Chinese athletes who are usually unaware of the rules, and now they are embracing the protection afforded by the rules. However, if you're the employer, you're a Chinese club, for example, you probably would like to exclude this kind of mechanism and try to ask for the resolution by the Chinese courts, for example. It doesn't mean that the Chinese courts will be more favorable for the employer, but in some circumstance, I think they will be more acceptable for the local circumstance, and also the FIFA extensive power and mechanism for sanctioning clubs or member association wouldn't be applicable if you're choosing the court mechanism. So this is, I think, different position, different status will be decisive on which route you're going to use. So for the type of these kind of disputes, I would invite Rafaela to probably add her insights, and then we could also discuss why we think that arbitration is more suitable for resolving sports disputes.
Thank you, Guo. I think you have more or less covered the types of disputes, commercial disputes that are regularly brought in front of CAS or other institutions that are sport related, like the broadcasting and I think the employment related dispute is a particularly interesting topic. Also, with regard to the evolution you had in China with the decisions in regard to the employment matters on the jurisdiction of employment in football. This is even more so as through COVID-19, I mean, that happened all over the world and impacted sports all over the world. FIFA has, with regards to employment, issued some regulations and rules on what justifies a suspension of the payment of the salary or not, whether it is, and this is even more important because of the globalization of sports and the fact that it is now also transmitted all over the world and broadcasted all over the world, that the FIFA regulations as well as sports arbitration tries to ensure a certain fairness or level, fair level of treating people. It's because if you are, let's say, the German coach, and depending what country you travel to train a club, if you rely on sports arbitration and the interpretation of the FIFA regulation in that regard, you have a certain reassurance or certainty on how you will be treated if your salary is not paid. Whereas if you travel to any country and are bound to the local rules, then that gives a big uncertainty to the whole sports industry. And this is certainly one of the big advantages of arbitration, also in regards to employment matters for these specific cases, because they travel so much and they may be bound to. Also, the players, if they are bound to decisions of local courts in countries they have no relation to and have no do not master the language or anything, this can be quite difficult and stressful. And as you said, I mean, sport is global, and it's becoming even more so through the whole evolution of technique, video broadcasting, YouTube, and so on. So the challenges are not only the challenges of one local court or one local jurisdiction. These are worldwide challenges, and the advantage of having specialized sports lawyers and arbitrators and courts that deal on a daily basis with this kind of situation gives a certain guarantee to this global aspects. The other thing of course that is also quite important is that if you have an arbitral award, you can enforce it quite easily through the New York Convention, to which also China is a part. I'm not absolutely sure whether the employment disputes can be easily be enforced in China, because I understand that China has made a restriction to apply the New York Convention only to commercial disputes. So this might be something that needs clarification, but with regard to all other disputes, commercial related disputes, they can be and are, as for the reason I mentioned before, certainly of advantage if they are dealt with by sports arbitrators. Not necessarily under the CAS rules, it can also be under the CIETAC rules and some others. There's one other point that we discussed that is also of interest, is the possibility under the CAS rules, but also the CIETAC rules, to render awards by consent, which will then also be easily enforceable through the New York Convention system. And the fact that there is a possibility for the parties to save time and money in certain situations where the proof will be difficult, or they finally find an agreement. This is also a big advantage, and this is possible under the most institutional arbitration rules, including CIETAC. I've seen they do that as well. So this is my comment.
Yeah, and thanks, Rafaela. I think you have also, you already touched upon like a few advantages of arbitration as a method of resolving sports disputes. I could just summarize for the interest of the audience and also give them some example. And of course, you can jump in if you have further comments on that. So actually, Jeff and I co-authored, I think for 2 consecutive years, as like a sports annual review on sports dispute resolution in China. And there we advocated mainly that arbitration is really the preferred method. It's not just a slogan, it's really supported by solid facts. So give you some examples. So first of all is so arbitration is created for international cross-border disputes because the court is more jurisdictional and territorial. In sports in itself, it has a nature, it has a transnational nature, because in world championships, in World Cup, teams from different countries or athletes from different countries will have to compete head to head. So they will have to abide by a uniform set of rules. So for example, so referring back to the salary employment related disputes for football players or football coaches, you will find that if you are opting for arbitration, then the rule applicable in the first priority is not actually national law, no matter what you provide in the contract, because usually the clubs like to provide in the contract that the applicable law is a Chinese law or English law. However, if it's a football case, it's very likely whatever you provide for in a contract, the FIFA regulation will prevail. And it has a reason, because as Rafaela says, if a German coach or a Dutch coach comes to US or in China for his work, he has to have certain security, and you can't assume like a foreign coach or player knows the local rules that well. So he could always rely on the safeguard provided by safeguard provided by the FIFA rules. So that is a uniform set of rules, but sometimes it could be very, very expensive by Chinese or other local standard. And the second thing is that so for arbitration, we have this advantage of engaging expertise and specificity, because for judges of different jurisdiction, they might not be very familiar with the each specific rule for applicable for each sport. But in arbitration, you have the liberty to choose the arbitrator who knows the rules. And we could elaborate a bit on the football jurisdiction confusion here in China, but we don't have enough time today, but maybe saving for next event. And of course, speed is an essential factor as well, because I think Mr. Bai have elaborated on the advantage of, in the aspect of speed. But for example, for the sports cases I'm aware of, it usually will run like from 5 to 6 years, or even more, because the parties can appeal, and also the judges are not very familiar with the sports specificity. So it requires them a lot of time to study and to communicate about to be aware of the rules. So that is so you could take like up to like 7 years to enforce like 50,000 RMB. So that is certainly, I think, a major advantage of arbitration compared to litigation. Finality and enforceability, Rafaela has touched upon it. And I would also just add one point, is that there is also a possibility for enforcing like a mediation, like a decision endorsed by mediation by way of Singapore Convention of Mediation. And last but not least, we just touch upon the possibility of something called arbitration by arbitral award by consent. So that says something about the possibility of being creative using arbitration. So I know my time is up, but I can just conclude by this little example of an actual case. So for example, there is like a monetary claim from the rights holder to the local operator for the licensing fees. So there is some fees owed that they would like to pursue by arbitration, but they also like to preclude the possibility for future defaults. So if we go by court, it is not very possible for you to persuade the judge to rule on something that hadn't happened. The judge can rule to order your compensation for something that had already been defaulted, but the court will be more rigid in terms of something that is not very certain. But for arbitration, the parties can always reach a settlement agreement that says that you have to be punctual in your payments. If there is any default in the future, then we can cancel the agreement immediately. So in that case, we actually endorse this arbitration agreement we actually endorse this settlement agreement by arbitration. It's like an arbitral award by consent that actually rules on something that hadn't happened yet, but gives parties more security and certainty. So that wraps up my session. And unless Rafaela has more points to add, we can pass the floor to the moderator.
I think that there would be much more to discuss, but I believe that that now is the time for discussion. So thank you very much for having listened to us.
Thank you.
Thank you so much for your very insightful sharing as well. I think we can have time to further elaborate on the topics that we've covered in the panel discussion. I'm going to briefly introduce our panel moderator, Mr. Jeffrey Benz. Mr. Benz is a dual qualified U.S. attorney and England and Wales barrister and a sought-after ADR practitioner based in London and Los Angeles. He has been recognized repeatedly as Lawyers of the Year for arbitration in Los Angeles and was recognized as one of the best lawyers in America. Mr. Benz has also developed a sports-focused specialty. According to Who's Who Legal 2018 to 22 UK Bar, he is widely recognized for his first-rate arbitration practice, and clients know he is in a class of his own when it comes to complex sport disciplinary disputes. In 2016, the BBC noted Mr. Benz is widely regarded as amongst the most experienced judges in world sports. So now over to you, Mr. Benz. Thank you.
Thank you very much. Thank you for having me. I have served on many panels speaking over time, but this is the first time where I've had the good fortune of serving on a panel where I have either served alongside everybody or worked alongside everybody that has presented to you today. And it had nothing to do with me. I didn't pick everybody. I was picked just like everybody else was picked. But I think that shows the nature of the specialized nature of the sporting endeavor and sports dispute resolution generally. It doesn't mean it's a closed shop in any way. There's plenty of turnover of people coming in and out of the sports dispute resolution area. But I do think it shows that it helps to have a sporting background and sports experience to participate in all of this. So I'm going to try to do two things. First of all, we have a Q&A tab within the Zoom, and I'm going to be monitoring that and asking questions from that. If any of you wish to ask questions of members of the panel, or God forbid, even of me. I also understand we have a WeChat live stream. I will not be able to see those questions, but perhaps the staff at CIETAC can monitor that and see if there are any questions that come in through that. And finally, we'll combine what was a moderated session with the Q&A and try to have our speakers further elaborate on different points that they may have raised or points that I may have thought of while they were speaking. The first one that's been touched on, which I think is pretty interesting, those of you that are involved in the financial sector out there know that the Shanghai Financial Center had a quick rise. The same year that Deng Xiaoping pointed across the Huangpu River at what was a rice paddy and said, over there, we are going to build Pudong, the financial center for Asia. That same year, the Chinese legislature passed a sports law that said, we will build a sports arbitration and mediation tribunal. It took them until this past year to build that. They built Pudong pretty quickly, but it took them until last year to put together this sports tribunal. It's been touched upon a bit by Guo, and the amendments to the new Chinese sports law have been touched on as well. But I just was going to ask a question culturally. So for a sporting nation of the size and scope of China, it has relatively few disputes that make it outside of China and are seen by the rest of the world in the systems that exist. If you compare the sporting activity of China with the United States or with the UK or with Switzerland, you will find a much higher percentage or a much higher per capita number of disputes that come out. And I just wonder if the building of this new sports-specific tribunal, if you think it will have an effect on teaching people in China how to fight with each other within the sports industry, within construction, within energy, within sport. We all know that everybody has a culture of how to fight with each other and then get along after that. In esports, they do not have that. Esports, for those of you that don't know, is competitive computer gaming, where you go head-to-head in computer games, and it's a rising, growing area of probably sports laws where it'll end up, but they do not have a culture of knowing how to fight with each other. And their fights are very ad hoc and interesting. And some of them come to me as a mediator and an arbitrator in Los Angeles, but they're not particularly schooled in how to do it. And I'm just wondering if the building of this new tribunal in China, what your thoughts might be on what effect it could have on allowing or permitting or finding ways for Chinese athletes, sponsors, governing bodies and the like to assert their rights or defenses in ways that may not have gone on before. Any reaction from my Chinese colleagues?
That's interesting. Yeah, Jeff, or well, both Mr. Song, Mr. Professor Liu, and I were involved in that. the process of setting up that, the China, what we call CCAS, the China version of CAS. It's actually called China Commission of Arbitration for Sports. You can hear me okay, yeah? Jintao?
Yes.
Okay, cool. Yeah, in reply to the question raised by Jeff, that is an extremely interesting question, I think. It touched upon some of the really, Chinese kind of a characteristic side of the sports dispute. Well, over the years, it's true. Yeah, over the years, you don't see many cases or sports-related disputes arising from China. I guess one of the reasons, or there could be many, and also you're very sharp on pointing out the same time, the same year where Deng Xiaoping pointed out that rice paddy and saying, we're going to be Pudong. The same year we kind of adopted the original version of Chinese sports law, but it takes 40 years, 30 years, something, yeah, to have CCAS finally, yeah, last year. One of the reasons, I guess, there are many. One of the reasons could be, sports activities to a large extent in China is sponsored by the state. Yeah, unlike many other countries, where in the U.S. it's a completely commercial side of the things. Yeah, unlike China, it's mostly, most of the finance come from the state. So the owners of this type of activities, as well as dispute that might arise as a result, does not from the individuals, well, does not from most of the time it comes from a particular organization, which is also a state-sponsored organization. So sometimes it doesn't make sense for them, for the parties involved in any dispute. There must have been disputes, of course, but probably just of a different nature. So it probably doesn't make sense. In the first place, we don't have an institution in place. So even if there were disputes, there must have been. They don't surface they don't come to the attention of the public, and they are resolved, through other channels by other means. And I guess once the CCAS, the China version of the CAS, is established, simply because you have a official kind of a recourse available for remedy, then there definitely will be more cases that will be brought to the attention of the general public. And commercial disputes or sports-related commercial disputes will be able to be adjudicated by this official kind of a body of dispute resolution. Going forward, I do anticipate that there will be many more cases, and it'll be interesting area of practice for lawyers, for arbitrators as well, I guess. So I'm personally kind of excited about this. Yeah, Mr. Lu, do you have anything to supplement?
Yes, yes, thank you, Jeff. It's an interesting question, but I think the purpose of establishing this China Commission for Arbitration, China Commission of Arbitration for Sport, is not to teach Chinese people how to fight in a new tribunal, in a new platform. The purpose of, you are quite knowledgeable about the Chinese sports law. The sports law was amended last year, which enables the establishment of this CIETAC. Maybe I can call it CIETAC because CCAS, China Commission of Arbitration for Sport. CIETAC was established formally last month. Well, there has always been disputes, sports-related disputes, but previously those disputes are mostly settled within the different sports association, like Chinese Football Association, Basketball Association. However, what many people think that these associations, being part of the parties or being a party to the dispute, also serves as a judge to the disputes. So the result may not be always be satisfactory. The establishment of this CIETAC will, I think, facilitate the players, the athletes and coaches and other interested parties in the sports area to have their dispute settled more fairly and efficiently. I think that's the purpose. It does not has anything to do with foster or change the culture of fighting and dispute in a court or tribunal. So
can I just add something, because I have a slightly different view?
Okay, go ahead.
Sure, go ahead.
Yeah, so actually Jeff mentioned that why there is less disputes known to the outside world. I think it is related to Chinese culture, because Chinese people generally do not like to fight, especially fight in the public. And if you are looking at the recent disputes, like the serious waves of disputes for overdue salaries raised by the usually silent, obedient Chinese football players, you can see that there is a visible change from their attitudes before and today, because before they usually they are very embarrassed for raising any suits against their employer or even the governing bodies, because they are regarded by others, and even there is a self-criticism that they are the subjects or the governed subjects by those bodies and employers. So yeah, I think in Chinese culture there is a general embarrassment associated with those being managed to sue those managers, right? But right now you see there is a visible change. So I think there is already, this is a visible improvement. So I guess that's why before you didn't see a lot of disputes, because people generally do not like to litigate like you guys in the UK or in the US, and it's like a cultural, because I also see that there is a interesting contrast, because usually when the UK businessman or US rights holder doing business with a Chinese party, it's very common for the UK or US parties to be very aggressive, like suing or threatening with a demand letter when something doesn't was not all right. But maybe for the Westerners, it's very standard thing to do, and it's nothing offensive. But the Chinese party would usually take it as an offense, and things will go sour from the minute when they receive that lawyer's letter. So there is indeed like a very sharp or like a dramatic comparison culturally. And the second thing is that I think the reason why it was so slow for establishing this CIETAC is also, I feel, my personal view is that I think for such mechanism to succeed, it's crucial for anyone involved, the stakeholders, especially the people who are designing the rules, to really understand the fundamentals. And I think it takes time and it takes lessons. So I hope this time it can go well. Yeah.
Thank you. So I'm told that we can go a little later than our scheduled time. We won't abuse our audience that much, but I think that the answers to that question were interesting. It sounds like it's going to mean more work for lawyers and arbitrators and mediators, so yay. Let me ask a question that perhaps Raffaele can take on with her background in commercial and also in front of the cast. So commercial institutions and international commercial arbitration lawyers talk about emergency measures, provisional measures, and the like, and this is a way to get fast relief, and sometimes it means sometimes that means the end of the case effectively because of the legal tests that go into considering provisional measures or emergency measures. Sometimes not, but the ad hoc division and in the speed with which it operates would put any International Commercial Arbitration Tribunal to shame with respect to the speed at the way those cases flow, and the information gaps probably that lawyers would naturally feel that are there because they don't have enough time to prepare their case or the like. Maybe Raffaele, you could talk a little bit about that speed element and how does that all come together? How does it all get done so quickly? And what is the practical element of how quickly it gets done?
Well, this is an excellent question. I think the speed element is heightened during the Olympic Games and when you are in an ad hoc division, because there you have like 24 to 48 hours. But I mean, there's one on the practical aspect. There's several things that make it possible. First is the choice the selection of the arbitrators. I mean, all of the arbitrators that are chosen for the Olympic Games for the ad hoc divisions are experienced arbitrators. So they don't need to take too much time reading the rules or the regulations, and even less so the code. And that certainly makes it faster. They also are usually used to rendering fast decision, if not as fast, and still, like you mentioned, in emergency arbitration situation or in provisional decisions, sometimes it's even faster. I had a case that, where the panel rendered a decision within 3 hours, I believe, or maybe 4 hours, but at least still the same day. So, but there as well, experienced arbitrator who know how it works, what is important. The other thing that is also usually the case at the Olympic Games is that the attorneys involved, the lawyers involved, are also very experienced. They know exactly what they have to bring to get a fast decision, so you don't lose too much time on and there's of course the other practical issue that is of importance. You lose no time at all regarding all procedural decisions, because these are dealt with in the specific rules for the Olympic Games ad hoc divisions. So it is very fast and efficient, I think, mostly for these reasons.
Thank you. Yeah, they're not gonna turn the 17 days of glory of the Olympic Games into 18 days to accommodate more time for lawyers to arbitrate a case or arbitrators to render a decision. I wonder if my other colleagues who are CAS arbitrators have any other thoughts on this.
Jeff, as I mentioned, during the second half of the Olympic Games, most of the dispute will relate to what we call field of play decisions. Normally, those decisions in deciding dispute relating to field of play decisions, the arbitrators will defer to the knowledge and judgment of the field umpire or the judges. So only in exceptional cases where fraud can be proved, then the tribunal will overturn the umpire's decision. So that's very exceptional. Another factor is that the tribunal has no privilege to enjoy more time, because tomorrow the player will enter the next round of competition. So you have to give them a decision. You don't have time to render your decision in a week. Then the game will be over. So whereas in the commercial dispute, you have a contract, maybe 100 of pages, and there are being performed for years, and there are a lot of things happened, so it's more complicated. So that's different. And there are other factors for the composition of the tribunal, for instance, which makes the 24-hour time limit decision making possible in Olympic Games.
Thank you. So, so to summarize that, commercial cases are more complex, and that's why they take more time. And just like arbitrators, referees can be wrong with impunity, and no one can do anything about it. But they better not be corrupt about it when they do it, because then the door opens wide for interference from others, including the courts. I'll ask one last question, and then I think we sufficiently well over our originally stated time that we probably ought to wrap it up. But let's talk a little bit about mediation, if anybody has any views on that in the sporting environment. Traditionally, for a whole bunch of reasons, mediation has not been practiced within typical international sports disputes. The most likely reason is the fact that a lot of those disputes are centered on the continent of Europe, where mediation is not as widely practiced or taught or used. But in China, it has a long tradition of mediation, both coextensive with the involvement with court cases and also with services offered by the arbitral institutions in China, including CIETAC, alongside the arbitration-related services. But any comments on the possibilities for mediation to grow as a mediator? I'm hoping this is the next new growth industry in sport and the like. But any views at all that you'd like to share, or you feel comfortable sharing, either on the commercial side or on the disciplinary side?
Mm-hmm. Yeah, Jeff, yeah, I might want to say a few words on that. Mediation is now increasingly, I would say, widely used across the board in China, in litigation, in arbitration. And one thing particularly interesting is over the year, over the past, I would say, 1 decade, 10, 15 years, you would see increasingly the Chinese courts at various levels are starting to introduce the mediation process, which I guess, I'm not sure, but according to my experience, I had one case in the US once, and particular types of cases below a certain value would go through a kind of compulsory process of mediation. This is the case, increasingly the case in China at various levels of the courts. And one of the purpose, I guess, is to reduce the workload of the courts, and also kind of giving a chance for the parties to settle before going through this long process of litigation or arbitration. And various arbitration institutions also have measures, have procedures in place to kind of encourage the parties to go through mediation and conciliation, mediation, etc. I guess in the coming few years going forward, I guess I would personally see a further substantial growth of mediation in China at various, dispute resolution scenes, including arbitration and litigation. One thing interesting about the Chinese arbitration, practice is that the rule does allow mediation to happen, unless, of course, the parties object. The same panel can be the mediator as well. Yeah, unless the party don't agree, they want someone else to be involved in the mediation. Otherwise, the arbitrator can be part of the mediation process, and the number of cases that are being mediated or have been mediated or resolved finally by means of a mediation and reaching finally a kind of a mutually acceptable resolution has been on the rise. So, and also China has become a member, officially become a signatory to the Singapore Convention on Mediation. So you see increasingly, becoming increasingly becoming a kind of a norm instead of an exception like 20, 30 years ago. Of course, there were mediation, but completely under a different legal framework at the moment. I think I believe the mediation will be getting bigger in the future in China.
Thank you. Any other insights?
So for me, I personally have, I'm a big fan of alternative dispute resolution because based on the cultural background, as I just introduced, that in China, we do not particularly like to fight. We like to talk and resolve any disagreements peacefully. And by personal experience, I think generally disputes, especially between foreign parties and Chinese party, it's actually there are a lot of things, disputes caused by misunderstanding and a lack of understanding each other, because sometimes, as I just introduced, like a lawyer letter from the Western party is a standard practice, but it will be taken very strongly and seriously by the Chinese side. And that's so the minute when the foreign party sends out the lawyer letter or the demand letter, the relation will will fall apart. So this is something usually not expected by the foreign parties. So a lot of disputes actually can be resolved amicably by the active communication properly by people who understand foreign culture or by somebody who can understand Chinese culture. And I just want to add that for mediation, the Chinese courts is a big fan of mediation as well. And usually the judges will try very best to settle a case by mediation, and they are very, very good at it. And I have an actual case that was resolved in this way, and the judge, they will actually work with each other, coordinate with each other to talk to the counsel for the claimant separately, and then proceed to the counsel or the defendant separately. And then they will, just hold a meeting and ask you guys to accept certain conditions. And sometimes they are also very observant in terms of observing what is your bottom line, and then communicate very effectively to the other party. So I was personally very impressed by the Chinese judges' ability to mediate disputes. But my experience with FIFA is that, the International Federation, is that they are not really a fan of this, because for example, especially for disciplinary cases, they will object to mediation or award by consent. But I note that there is a development, right, by FIFA in terms of mediation that you are involved with. Jeff, if you have time, you can probably also touch upon that as well.
Well, FIFA disproved my bias against continental Europeans being able to embrace mediation, because FIFA is the first major international federation to actually put together a mediation program that they've just now started to get going. There've already been a few cases within it, and I know they're hoping for greater adoption. Why do mediation? Of course, it reduces your case backlogs, and it makes for not only a less expensive process, but the ability for a more creative process to bring peace to disputes that might keep the parties separated when they really can be together. So I don't need to touch on that anymore. Is there any other views on the mediation question, or anything else we've talked about?
No, I just wanted to raise that I believe the reason Guo mentioned, in particular in international relations, is very important, because quite a lot of disputes do arise from miscommunication and misunderstanding, and they can be settled by mediation. However, the possibility to do a conciliation, or a mediation, need not be a separate proceedings. It can also be done by, as you said, the judges. This is something very usual in Switzerland as well, or the arbitrators. They can always agree to facilitate the dispute if they feel that underneath the dispute is not that bad. It's more a question of communication. So I think it's coming, and it's the more and more global sports becomes, the more these aspects will be important. And this reminds me also something was said with regard to the disputes, the Chinese dispute, that we don't see as much, but that now the players start to understand their rights and start to fight for it. I believe that this is also a result of the globalization and of the fact that people know what's going on in other countries and try to build on that. And so I think it's a good development that we have to follow, and mediation as a way of understanding each other is very important in that regard.
Thank you. Well, if there's nothing else, we've gone sufficiently over our time, but I know we've had an attentive audience both on the Zoom as well as on WeChat, I'm told, on the live stream. So I will now turn it over to Jintao to take us out, and thank you all for participating with me in this moderated session, and to CIETAC for allowing me to be here, and to our listeners for hearing us. Thank you.
Thank you
you.
so much. Thank you. So before we end this webinar, can I invite everyone to take a group photo? My colleague will do the screenshots. All right. So 3, 2, 1, cheers. Thank you so much. I think today's webinar is very fruitful and interesting, because I see, even though we are running late, but we see so many people crowding in on WeChat. We've hit over 1,000 views so far, and we are receiving over 2,000 likes. So I think today's webinar is a good success. So I hope that we can see each other in person very soon in the future. And also a big thank to all of you involving, and all speakers and audience joining us online today. So have a nice day. I hope to see all of you soon.
Thank you
Thank
very
you
much.
so much.
Thank you.
Bye.
Very good.
Bye.
再见。